So welcome to the Roundtable at the end of the ASYFAIR conference. So with this Roundtable, I hope that we can develop a kind of more zoomed out perspective on some of the work that we've been doing and make some connections between some of the different pathways we've been talking about during the conference. And I'm delighted to welcome the panel, which is very illustrious and distinguished panel that we've got here today. I'm going to introduce the speakers in turn as I go to each of them, rather than give you 9 paragraphs of introduction right at the start. And what I've asked the speakers to do is to limit themselves to 2.5 to 3 minutes in response to some questions that we've already got prepared. So without further ado, we're going to move on to the first question, which is, I'm actually going to skip the very first one, which is the key themes or insights. We're going to do that second, because I don't want to put Livia on the spot with the key themes one. I'm going to go for the second one. Are there specific theoretical or methodological insights that you would recommend to move our conversations forward on the asylum appeals that we've been discussing? And I'm going to go to Livia Johansson first. Livia is a political scientist at the Stockholm Centre for Organisational Research, Stockholm University, specialised in asylum determination research, legal ethnographies and interpretive analysis. She has a background in feminist political theory and a general interest in judicialisation of politics and public policy making, most recently blame management as political phenomenon. In a current 4-year research project, Livia studies the role of the administrative courts in the Swedish democratic system by conducting an ethnographic study of how equality before the law is practiced in asylum appeals compared to other administrative court procedures. Livia, over to you.
Thank you very much, Nick. And I would actually have preferred to have the first question first, because this one I'm saying now is kind of following from that. But
well, please don't do the first one.
But it doesn't matter. What I wanted to do was to kind of reflect on the years that I've been in the field. It's about 10 years now. And when I started, there were no such conferences as the one I visited here that you organized. So I think that's kind of an illustration of the growth of this field as an empirical field. But with that kind of as a background, I also think, and that goes as well for myself as I think maybe for the general field, if we can call asylum determination and asylum adjudication a field, but I think maybe we can start to do that now. So I definitely think that there are theoretical and methodological insights to make at this point in time when we see this kind of so many younger scholars, so many PhD students, so many new projects everywhere around Europe, at least where I am most familiar with. And although I myself is a single case study researcher doing ethnography and thick descriptions, that's always been like my way of doing research. I think that we need now to be a little bit self-critical and kind of reflect upon the dominance of these methodological choices. So when a research field is new and kind of unexplored, carefully describing it empirically with thick descriptions is the best way to go about it, right? But just to kind of see what are the different shortcomings and the advantages of the practices that we can witness in the field. But I think now that this is such an overwhelming body of knowledge demonstrating what the problems are, how injustices are created in these procedures, and which consequences it has for people subjected to those procedures. It's time to take a step back and kind of try to develop theories and explanation for why these injustices persist, how they can be legitimized again and again in courts and by policymakers. And I would really encourage all of us to kind of try to take this step back and try to actually explain what we are seeing now. And I'm just when we have Rebecca Hamlin in the panel here, I will also like to really point towards that kind of research that she's been doing, which is one way of doing it, to kind of compare across countries. That would be like, there are so many case studies that I've witnessed during these conferences, and to see kind of comparative research on that would be great, and really something that I think we can all benefit from. But I also think that we can benefit from this interdisciplinary approach that so many of us have, and we have kind of background in different disciplines. And I think that we should really use the kind of baggage that we have of theories within our disciplines to try to explain things that we see in this field. And I have a lot of suggestions how to do that, but that's really something that I would encourage everyone to do. So I want to see more explanations for what we see in this field. I think I stop there. Thank you.
That's fantastic, Livia, to get us started. And just to note, Tobias has done interesting international comparative work as well. Austin, Dr. Austin Kosher is an assistant research professor in the Newhouse School of Public Communication and a researcher with the Transactional Research Access Clearinghouse, TRAC, a research institute at Syracuse University that uses Freedom of Information Act requests to study the federal government. Key areas of Austin's current research at TRAC include federal immigration detention, enforcement and deportation, the immigration court system, and trends within the federal criminal and civil courts. Austin's research interests focus on the political and legal geographies of immigration, enforcement, policing, and the immigration court system. His ongoing work interrogates the legal rationalities and everyday practices of producing illegalized immigrants through the US immigration court system, and he examines how the immigration courts link up with local enforcement on the ground. He also examines the strategies and impact of grassroots immigration rights and worker rights movements that contest deportation as a tool of social and labor control. Austin, over to you.
Yeah, thanks so much for having me, Nick. It's really great to be here. So I think I'll just focus, make sort of 3 points with my opening remarks here. And some of this, you know, to the point about connecting what's going on in Europe to places outside of Europe, and sort of connecting this research across space and time. I really support that, and I really like Livia's opening comment here about just how much has changed in the past decade. I remember when I was doing my master's fieldwork in the U.S. South in 2010. I remember my first visit to an immigration court in the United States, and my first visit. 40%. Sorry. Connected to Austin's MacBook Pro. Little tech issue. My first visit to an immigration court in the United States, and just being so shocked that there was actually a court where decisions were being made about asylum and deportation. And I had thought at that time that, just how much deportation feels like a policing activity where someone gets arrested at the border or arrested on the interior of a country and just gets whooshed off to whatever country that the state has designated them. And in fact, there is a tremendous amount of political and state activity and labor that goes in between, in that process of determining asylum, determining deportation. So it really is great to be here and good to see the ASYFAIR project develop like this, because I think it is very timely, and it's such a culmination of important work and important changes in the global migration management system in the last decade or two. So just 3 brief points here. One, I just want to, and I really am going to touch on this question about methodology going forward. One of the things that I've really come to appreciate in my current position at TRAC, given how much we use FOIA and government transparency law to make government data available to the public, I think being on the inside of that work for about 2 years now, 2 or 3 years now, has really helped me to see the value in what I sort of call mapping the interior of the deportation state, which is to say that I think that there is still a lot of opportunity to just open up parts of the asylum adjudication system across the developed world, in particular, using Freedom of Information Act law to make it more, to make even just some of the basic facts about how these systems work more available to the public. And I'll come back to this in my third point. But I think this is both a quantitative and a qualitative sort of approach. It's both about saying, you know, what is the data that the government has that we can show how the government's states are working, but also just qualitatively. And I know that many of the researchers here are working on this, and this is obviously a focus of ASYFAIR as a research project, but you know, we certainly have not reached the limit on understanding the formal and informal processes by which not only asylum claims are adjudicated, but people even have the chance to get in front of an adjudicator of some kind. And so there remains, not just in the moment of adjudication, but there remains a lot of barriers even to getting there. You know, we know this with externalization policy along the southern and southeastern European border. It's happened along the US-Mexico border and certainly elsewhere. And so this remains certainly a point of interest going forward. The second thing I would say is, I think it continues to be upon us to connect adjudicators and courts and the law, you know, as some of these slightly more traditional, although asylum adjudications are never very traditional, some of these more quasi-traditional moments of adjudication, and to never ever let the law off the hook in terms of connecting those moments to broader social and political context and dynamics. And so never, I think never conceding the point which courts and adjudicators often want, which is some sort of claims to independence and objectivity and distinction from the messy reality of politics. And like I said, I know this is something that's come up a lot in the conference. And so in that way, to not only connect them, but also to disaggregate the state, I have found it quite productive to point out the places where the state is internally contradictory in many ways, where in fact the logic, for instance, of adjudicating asylum claims, you know, many of the people who are involved in that process are actually very well-intentioned people who want, you know, who many times want to do a good job, and find, you know, our intention with the more enforcement-oriented parts of the state. So I think drawing out those tensions and amplifying them still has a lot of value. And then lastly, and this is just also speaking a little bit to some recent experience I've had, I think that we can still do a lot of work inside of the academy and inside of this, inside of our research, to connect this work to the public and to the media, and to try to find ways to communicate things using modern media technology, using relationships with media outlets to try to publicize some of these issues and hold agencies accountable. So I'll leave it there. Thank you.
Thanks, Austin. And now on to Anthony Goode, who is Emeritus Professor of Social Anthropology at the University of Edinburgh and former head of its School of Social and Political Science. His principal oversees field research in South India, focused initially on family and kinship, and subsequently on the ceremonial economy of a large Hindu temple. In the 1990s, he acted as a senior social development consultant for DFID, providing advice on NGO-implemented community development projects. From 1994 onwards, he has frequently acted as an expert witness in asylum appeals involving Sri Lankans. He also made several brief fact-finding visits to Sri Lanka, producing human rights reports for use as evidence in asylum claims. He carried out ESRC-funded research into the uses of expert evidence in the British asylum courts, and with Dr. Robert Gibb, AHRC-funded research on the asylum processes in France and the UK. His current research covers legal treatments of animals and the environment. Anthony, over to you.
Okay, thanks, Nick. And actually, that early stuff on family and kinship, surprisingly relevant in the asylum claims. I've had to write lots of reports dealing with Sri Lankan marriage practices, for example. So it all hung together in a way that I would never have envisaged at the time. I'll be quite brief on this question, I think. A couple of rather diverse methodological points occur to me. One is an issue that I've never really solved myself, but I think is important, and that's to find ways of involving asylum applicants themselves in the work that we do in ways that don't actually increase the stress and the burden for them. It's very hard to figure out how to do that when someone's going through the trauma of having their appeal heard in a court. But there ought to be ways of foregrounding their viewpoint in a way that I've never actually found possible to do in my own work. So that's one issue. And then a second, a completely different kind of issue, has to do with the increasing use of video. So for example, all asylum interviews conducted by the Home Office are now to be done through video links. How do we as researchers have to vary our methods in order to cope with this kind of situation? What methodological challenges does that pose for us? So as I say, two rather different methodological points, but both of them, I think, in their own way, are quite significant.
Tony, that's great. And I'm going to put into the chat a couple of papers that touched on both of those issues involving appellants. Someone in the Italian session said that in and of itself, talking to experts by experience was a form of resistance, which really stuck with me. So I'm going to put that paper into the chat. And then Joe Hines's paper on the impact of doing ethnography online, disembodied ethnography online, was also really interesting. So I'll put them both in the chat. Thanks for raising those two issues, Tony. And now we're going to go on to Rebecca Hamlin, who is Associate Professor of Legal Studies and Political Science at the University of Massachusetts, Amherst. She received her PhD in political science from the University of California, Berkeley in 2009. Since then, her research is focused on law and immigration politics, with a particular interest in migrant categorization and the concept of a refugee. Her published work has examined how the United States and other liberal democracies use administrative agencies and courts to adjudicate migration and citizenship questions, and the political responses to judicial involvement of migration matters. Thanks, Rebecca, over to you.
Thanks very much, Nick, for that introduction and for inviting me to participate in this amazing conference. Zoom is a terrible thing in a lot of ways, but it's made connections, especially across the Atlantic Ocean, more possible this year, and I'm so grateful for that. One of the things that's really struck me over the past several days and even over the past several years, looking at our little field is, and this is a very similar point to the one Olivia made, how much it's grown in ways that I find very, very exciting. So when I started my research, my dissertation research back in 2004, there was very, very little empirical or ethnographic work being done looking at the practice of asylum out there in the world. And now we really can't say that. There's so much more. And I've been struck just over the past few days about how much rich empirical study there is being done, and I think that's a huge improvement in our field. It used to be so terribly dominated by doctrinal work, and now there's much more empirical work being done, which is great. The thing that I think we need to do next, and again, this parallels what Olivia said, sorry, but I really do think that we need to ramp up our comparative work, because much of the empirical work that's being done is very country specific. It's a deep dive into the RSD regime of one place. And it's very difficult for someone to assess what is actually common between the different systems when they're using slightly different language and conceptual terminology to explain the environment that they know best. And so I think common concepts is something that we should be working much more explicitly on developing and sharing, so that when someone articulates an insight about the country that they know best, that it's actually transferable in some way for someone who studies another context or jurisdiction. So how to do that? My bias, and I can only just share the way that I have come to believe is the best, is towards a regime analysis. So rather than looking at one actor in the system and telling us only about how first instance decisions are operating, or only about how judicial review functions, I would encourage people to look holistically at the system that they're looking at, and to explain how the different actors in the system relate to one another. So one of the questions that I had in the panel that I chaired yesterday about a country is, is doctrinal innovation functioning in a top-down manner, in the sense that are the courts the ones who are looking to expand our notion of how to interpret the refugee definition, or is that coming from the tribunal or an initial decision-making body? What are the drivers for change in the system? Who is the dominant actor in the system, right? Do the courts tend to be more deferential to the initial decision-making in your system, or are the courts fairly active in checking and striking down or reversing decisions that are happening in your system, right? Those types of questions. And the only other thing I'll add, in the interest of being brief, is to always be mindful of the political dimensions of this, right? So these systems are highly political, in my view. The way in which countries decide how they're going to decide who qualifies for refugee status is a political project. It's a political decision. And the systems are set up to have a certain outcome. And they don't always function exactly as they're designed, but to be mindful of the design element and the role of political forces in shaping the system at all times. So where are the vulnerabilities in the system where forces of exclusion are most likely to intervene and put pressure on the system when public opinion in particular is taking a turn against asylum seekers? And so the final thing I'll say here is, and that this is also similar to Austin's point, is that we should be using the same analytical tools that we use to examine RSD, to examine even looking more holistically outside of simply just RSD, to understand other practices of bordering and exclusion. So how are the same lessons that we're taking when we understand the RSD system, how are those lessons shaping questions of complementary protection, questions of detention, questions of exclusionary or externalization? There's bordering practices that occur at stages far prior to RSD and screen people out. And I think these same insights can be used to empirically and even ethnographically study those practices.
Great, thank you, Rebecca. Really good points. I'm going to move on to Cristiano, who is a senior research fellow and lecturer at the South African Research Chair in International Law, Faculty of Law, University of Johannesburg. He holds a laurea equivalent International Relations, University della Studi di Perugia, a master's degree from the Italian Society for International Organization, Rome, a 2-year diploma di studi approfonditi from Geneva, and a PhD in international law from the same institution. His research and teaching interests mainly focus on the legal protection of asylum seekers, refugees, migrants, and IDPs in Africa, on African human rights law and more broadly on the development of public international law in Africa. Cristiano, it's great to have you here. Over to you. You are muted, Cristiano.
All right. Okay, yes, you're right. No, I was just thanking you very much, Nick, to have invited me to be part of this very prestigious final roundtable, this very interesting conference that in fact deals with a topic that it's very timely. Actually, I would say that it's very timely for many years here in Africa, in fact, because as you may know, I mean, we are having a lot of problem on the entire continent in adjudicating asylum cases, and we have even more problem with the appeals. Me, I'm living in South Africa, but of course I travel extensively throughout the continent. And when people think of refugee claims and adjudication and appeals, he always have a standard like, you know, what happens in South Africa, that it's possibly, under this point of view, the most developed country in Africa. So I mean, I agree a lot with my colleagues said before about, you know, to make a comparative analysis, but among different reality. But what is very important for us here, it's really to understand authorities and governments that is important to adjudicate on refugee claims and also to allow appeals. If you do just a simple research on internet, you will see that the refugee appeals in Africa, I mean, they are very, very few compared to millions of refugees on the continent, in fact. And one point on which I would like to focus is that it's the information on how to appeal that it should be very much implemented. So we should really, you know, give practical information, because information accompanying a negative decision should specify precisely how to lodge the appeal, name the relevant appeal body, and state any applicable time limits and the consequences of a failure to adhere to the time limits. That they seem very, they seem affirmation that are taken for granted in North America, in Europe, but they're not so obvious on the African continent. Also because, you know, the time limits, for example, it's something that needs to be, you know, meet. The most part of refugees in Africa, they don't even know often their rights. So, of course, methodologically, it's very important that the NGOs that are already doing an amazing job on field, they can even implement that, because there are still so many caseloads, they remain uncovered by the opportunity. I mean, you know, to lodge an appeal is already a step forward that possibly the 1% of the African refugee can accomplish. So,
Oh, we've had an interruption for Cristiano, haven't we? Is that just me, or has everybody lost Cristiano?
No, I think he just cut out for everyone.
What a shame.
No, but I can see you.
Okay, Cristiano, yeah, we lost you for about 10 seconds there.
Okay. No, I was just highlighting the, you know, the need of really making something concrete in order to allow African refugees to have access to something that outside this continent can be given for granted, but here is not granted at all. And as I said, we have local NGOs and local institutions that they are trying to make, their best in order to allow refugees to know their rights. But what I'm advocating is really to really come to the concrete. It's very important, the elaboration of theories, but sometimes theories that they apply in Europe, they cannot, they don't apply in other continents for many reasons. I mean, there can be reason of different kind. They can be political, but they can be even, sociological, in the sense that in Africa there are still ethnic group that they are discriminated, so they are not even allowed to apply for asylum in other countries, because maybe the neighbor country, they historically discriminate them. So it's important to try to put the experience of the best practice of other countries and other continents here in Africa. But on the other side, we really need to to sensitize authorities of many countries here on the continent to understand that the appeal is a right of the refugee, because in many instances here is still seen and considered something superfluous, like something that, it's not important. Even if on paper we have plenty of laws here and regulations as well, plenty of also many countries that they have some sort of appeal institution, but do they really work?
Thanks, Cristiano.
Yeah.
Yeah, no, they're great points. Thank you. We're going to have to move on to our next speaker, but we'll come back to you and hopefully hear some more from your perspective as well. Great, thank you. Tobias Euler is next. Professor Euler studied sociology between 2005 and 2009 at the London School of Economics and at the University of Cambridge. Tobias has been working at the University of Bern since February 2012 and also a visiting scholar at the Centre for Socio-Legal Studies at Oxford and a research fellow in the Department of Anthropology at the London School of Economics. Tobias is either author or co-author of the books Inside Immigration Law and Migrants Before the Law, translated as Behind the Border Before the Law in the Hamburger edition, co-editor of special editions of Journal of Ethnic and Migration Studies, Qualitative Studies, and the Journal of Organizational Ethnography, and associate editor of Civic Sociology. As a legal sociologist, Tobias Euler researches the use and effects of law in society. Tobias, it's great to have you here. Over to you.
Thank you. I think many good points have already been raised. I'd like to stress a few points from kind of the social legal perspective that I try to kind of take on. One is I agree that the kind of next step could and should be more comparison. That's something that Livia and Rebecca both, I think, raised very strongly. And I think comparison, we are at a stage in knowing a lot about RSD where we, I think, can compare more carefully as well. So we can not only do country-to-country comparisons, but we can be more specific. We have so much knowledge, and we've seen this in the conference, about specific questions of professional ethics and values, of questions of legal education, of questions of political mobilization, of questions of procedural law. And I think we can really compare not just country to country, but specifics of RST across countries better and more systematically to kind of gain more knowledge. And that I don't think, and I also have an ethnographic background, I don't think it has to be the same people that do the ethnographic work necessarily. It can be people who kind of use the knowledge that others have produced that kind of make more sense of it. And in, I think, general migration policy, people like Mark Helping have done wonderful work in kind of using others' data to do research like that. And I think that's something that we can see and should see in RST as well. And another thing I would stress is field-to-field comparisons. We know enough about RST now that we can, I think, look to the experience of certain areas of criminal law and see how procedural law reforms have affected criminal trials or criminal appeals compared to what we're seeing here. I think that would be something fruitful, because we're not just dealing with a black box anymore. I think that's the key kind of move that we have to kind of acknowledge. We're 10 years past in a way of saying this is a black box. This is something we know a lot about, and with that also can compare more justly or more carefully. And maybe the last thing I would like to, and I would also, of course, stress the point that Cristiano mentioned, that the question of translating theory into something that is relevant for practice, translating comparisons into something that is relevant for practice remains kind of part and parcel of our work. The last thing, though, is I think what became clear from this conference particularly, but from many conferences like it as well, is that there are kind of, in RSD or in migration research in general, there are unresolvable paradoxes. There is this question, we don't really know what to do with it. It's there, it's a problem, it's not a problem, it's both a problem and a solution. We have to deal with it. We have to deal with the fact that even a perfectly, from a procedural justice point perspective, fair system might provide results that we find unfair, because we have problems with the asylum system in general, or because we have sympathies towards a case that are different from what we might see from a procedural perspective. So there are kind of these paradoxes that are, I think, unresolvable, that we have to think with and deal with and engage with in our theories and in our research more. So I'll stop there in the interest of time. Thank you for having me.
Thanks, Tobias. That's great. And we're going to move on now to Professor Helena Ray. Professor Ray is Associate Professor in Migration Law. She's taught, researched, and published extensively on migration law, particularly family migration and citizenship, and has since 2011 been editor of the Journal of Immigration, Asylum and Nationality Law. She has led or been involved in several research and consultancy projects and led teams that provided expert evidence in 2 test cases heard in the British Supreme Court. In 2015, she was the lead author of a major report commissioned by the Children's Commissioner for England from Middlesex University and Joint Council for the Welfare of Immigrants, and launched in Parliament, on the impact of the financial requirements in the family migration rules on children. In 2013, she gave written and oral evidence in the House of Commons at the All-Party Parliamentary Group on Migration's Inquiry into Family Migration. Professor Ray teaches immigration, nationality and asylum law at the 3rd year undergraduate option and international migration and the law to postgraduate students. Before coming to Exeter, because she's at Exeter University with me, Professor Helena Ray was an associate professor at Middlesex University. She has a PhD from the University of London and is a former solicitor, having worked for some years in a City of London law firm. She was a founder member and for many years chair of trustees of Barnet Law Service, a law centre in the London Borough of Barnet. Helena, it's great to have you with us.
Thank you, and thank you for inviting me to contribute to this fantastic roundtable and encourage me to take part in this really very rich, excellent conference. I mean, a lot of the things that I was thinking about have been mentioned, but one of the things that has really struck me is about what we can expect from the asylum appeal system. And to some degree, I think to do that, we need to go back to first principles and ask the question, what is an appeal system for? What is it aiming to do? And I think that can, and I think work by people like Robert Thomas is very useful on this, because I think that there are 2 ways of understanding this. And one is about justice in the individual case. So, and this obviously is very important for the individual at the appeals tribunal. The outcome of their appeal on that day is obviously of huge significance to them, and the sense that justice has been done for them is extremely important. But I think it's also, I'm thinking also it's necessary that we look at what the appeal system can do in relation to the total administration of asylum law, and the idea that actually it is really part of the implementation of asylum law, and that when judges are making decisions, they are speaking really to the entire system, which has been constructed and set up by governments and decision makers to fulfill their international obligations. And I think that this is a critical role that we need to focus on, because I think it very much goes to not just talking about what it is like for the individual who is before the court, and I think it's really important that we talk about things like how they're feeling and the interruptions and the ability to have their say and so on, but also about what messages are being sent back to the decision makers, bearing in mind that appeals are really only a tiny proportion of the number of cases that are heard, and therefore the wider message is really very important indeed. And there I think that there is judges do have discretion, but I think in addition to using their discretion wisely, I think that they can also, I think the aspects of procedural justice are really important here. And I think there is a tendency sometimes for some judges to be a bit overindulgent of the government in terms of their procedural defects and their sort of failures to observe due processes. And it must be very tempting, the difficulty, being a judge is not an easy job at all. And, you've got lots of cases and you've got a case before you that might appear quite weak. And it might appear that in the individual case, no great injustice is served if the interpretation was poor, if the interview was carried out in poor circumstances, if the government served its papers at the last moment. Any of those things might seem unimportant when a case is destined to fail. But I think that it is actually really important that judges use those powers. And I think that, the things that we've talked about in this conference, looking at the sort of vast range of ways in which a right in international law, but a right that has got no kind of international law procedural guarantees. I mean, the problem with the Refugee Convention, it sets out a legal obligation. It doesn't really set out how that legal obligation is to be implemented. And I think that, we look at the very large number of problems that we've seen through this conference around non-suspensive rights, around detention, the terrible conditions in detention and the effect that has on people's ability to exercise their rights as well as their general well-being, the lack of legal aid, etc. That I think that it is really important that judges bring all of those issues to the surface. So they have quite a unique opportunity to do that. And so I think that's one of the really important things I'd like to see coming out of this, is that, I think we can we've got lots and lots of information, lots of really interesting data. We can actually use that to try to shape how judges do their work. Thank you.
Fantastic. Thank you, Helena, and a good positive vision for how we can use our research. I'm going to go on now to Professor John Campbell. John is a social anthropologist who undertook his doctoral research in West Africa before teaching urban sociology at the University of Dar es Salaam, Tanzania, in the early 1980s. Subsequently, he taught at Queen's University Belfast, Northern Ireland, at the University of Swansea, Wales, and at the School of Oriental and African Studies, SOAS, London, from where he retired in 2018. He's written 2 monographs about refugees and asylum, and a third about the quality of justice in London's magistrates' courts. John has published widely and has also worked as a consultant in international development Over to you, John.
Thank you, Nick. Thank you for the introduction. Being at the bottom of the totem pole means that many of what I would have said has already been noted. But yes, I'll say briefly, comparative research, absolutely, in a variety of dimensions. Many of the projects that we've seen, many which are published elsewhere, are simply too narrowly focused. And we need to examine, in each of these cases, the much wider political picture. We've talked about this in some of the earlier sessions yesterday. That may mean looking above the individual tribunal to compare different tribunals. It may mean looking up the system to the relationship to the appellate courts. It may also mean looking at the supranational, super-regional level as well. But there are similar processes going on across all these different countries, which mean more restrictive policies and a reduction of resource coming into key elements of the asylum system. So we need to look at more than just tribunals and judges. For example, we also need to look at the very important gatekeepers, who are those who take in the Home Office and the equivalents, the initial decisions on asylum applications, against which many people are unable to appeal for the wrong reasons. So there are a variety of issues here around gatekeeping and statecraft, as a previous speaker was talking about, which we need to bring into the picture. To do this, I propose something which Livia has already picked upon, interdisciplinary research. We really need to be much more interdisciplinary in our work. And I mean sociologists with geographers, with anthropologists, with lawyers, and we need to devise a truly interdisciplinary format to do the research in, so that we're all speaking and looking at the same data, examining it from a variety of different perspectives. Now, one possibility to do this, and I suppose it reflects Tony's comment about the difficulty of incorporating asylum seekers' perspectives into this. But it is important that we never forget that the key type of person that we're concerned with here isn't the judge, whatever power they have. It is with those seeking refuge. So one of the things we can do is we can explore a tribunal or a legal process or the appeal system from a variety of different perspectives, from the different actors, from the Home Office to the judge to the legal representatives, but most importantly from the asylum seekers' point of view. And as Cristiano noted in his research on Africa, even those who speak English, who are here in the UK, or speak French or Italian, have limited literacy abilities and the language in which they're expected to present their case. And they certainly have virtually no legal literacy to understand what their rights are. So we've got to make sure that these issues are addressed in the research that we undertake. Thanks, Nick.
Thank you, John. And last but by no means least, Professor Ashley Turlow is a Professor of Sociology of Law at Radboud University, Netherlands. She is chair of one of two research centres of the law faculty and is responsible for the Institute of Sociology of Law and for the Centre of Migration Law. She's also the chair of the Myers Committee, Standing Committee on Experts in International Migration, Refugee and Criminal Law, the chair of the journal. Oh, we said this the other day. Ashley, do you want to say it for me this time?
It's Asylum and Migration Law journal, course, yeah. But a Dutch one, yeah.
And is responsible for the sector plan on conflict resolution, for which Radboud University collaborates with the universities of Leiden and Utrecht. In the past, she has worked at the Office of the District Court of The Hague and was the head of the Refugee Department at Amnesty International Netherlands. She has also been a member of the Dutch Committee on Equal Treatment and was a deputy judge at the District Court of Gelderland Migration Chamber from 2011 to 2016. Ashley's main research topics are asylum, non-discrimination, and the working of judicial institutions, and she's published extensively on the administration of justice and migration law. Ashley, over to you.
Thank you, Nick. And thank you very much for this very rich conference. I think that bringing all those researchers together already very much contributes to the aim of comparison that is found important by Livia, Rebecca, and John, and I think everybody here, and also by me. I think comparison is very important. And maybe to add something new, I think we have to insist a bit more on transparency. For example, in the Netherlands, not all judgments are published, and the judges themselves decide what is an important judgment. And I think for reasons of science, we need to have all judgments published. So comparison is very important in my view. I also agree with earlier speakers that we need to explain and we need interdisciplinarity. With regard to explaining, I think politics are very, very important explanation. Aiming at restrictive policies is so influential on the whole administration, judgments, everything. But we, of course, also have to look at other explanations, and maybe we have to take a bottom-up approach, and maybe that connects with what John Campbell said, that we have to start with the individual asylum seekers. But I also think we have to look more at relations, the relation between the court and the administration, the relation between the district court and the appellate courts, relation between courts, different courts, and between between judges within courts, and the relations of courts with lawyers and courts with the legislator, and maybe courts with scientists. I have very good experiences in working together with courts and with individual judges. Another point I think we need to focus on, and I think that is also a thing that Anthony said, that is have a look at the advantages and disadvantages of both video hearings, and that was very often mentioned in this conference, but also video research. And also with regard to that, I want to say something positive. Last year, I interviewed many, many judges, and it was so much easier than before because I could organize it easily by because it was on video and it could be done between two other sessions, and I didn't have to travel. It was really time saving. The judges were very open. It was easier to get in contact, and it was less hierarchical. I think everybody has such a same flat screen. But I also saw the disadvantages mainly for the asylum seekers and their lawyers and the interpreters. So I think that we need to research further on this subject. And finally, I think I would really like to go deeper in the role of time, into fast procedures, long waiting periods, times for appeal, time pressure on judges, time pressure on the administration, time in camps in the region. And well, maybe that's enough for now. I have many other subjects I would like to research further, but it was an inspiring conference.
Great, thank you, Ashley. So we're looking at going into round 2 now of the panel, and we've had a relatively small number of questions in the chat, and actually directed to particular people on the panel. So I just invite the panelists to check the chat, and if you've got a question that's addressed to you, to address it when it comes to your turn. The other thing I've got an eye on is the time, because we've got about 45 minutes left. So it may be that we only get to go through one more time. It depends how much you speak for, obviously. With that in mind, what I'm going to do is to pose the rest of the questions that I had on my list now to you, and then allow you to choose where you would like to take it next time I come to you. Okay. So
maybe I may say something, Nick. I'm so sorry I have to leave earlier.
Oh, that's right. You did say, Ashley, yeah.
But I would like to say something on question 4.
Oh, okay, cool. So maybe we come to you first, Ashley. Maybe we go back the other way. That might work. Okay, we reverse the order. Okay. I'm going to read out the 4 questions that we have left, and then just allow you to choose your way through. Okay. So number 1, what key themes or insights have been most striking from the conference? And the next one, how would you recommend that asylum appeals change in the future, or what should we expect from asylum appeals? The next one, how can non-legal and socio-legal academics work most effectively with legal decision makers and system designers to have a real impact? And then the last question, in what ways can we stimulate global north-south conversations to improve asylum adjudication? So I'd invite you to just choose your way through those topics. Again, I'd ask you to limit your comments to around about 3 minutes a time. That might just give us a bit of time for open discussion towards the end. We're going to reverse the order. We'll go to Ashley first and go back the way through. So just as a reminder, that's going to go Ashley, John, Helena, Tobias, Cristiano, Rebecca, Anthony, Austin, and then Livia last of all. Okay, so thank you so much for your time, and over to Ashley.
Thank you very much, Nick, again. I would like to say something about working together with legal professionals as scientists. I think one option is to organize seminars together, and I have very good experience with the so-called Hohenheimer Tage in Germany, organized by both judges and scientists. And I think it's really very enriching, and that everybody is really open. The judges are also very open. The second thing is, I think it's good to get to know individual judges and practitioners, because that is really helpful to get the possibility to broaden your network within the judiciary. So get good contacts with some individuals. The third thing, and that's more professional, I think, that is make use of an amicus curiae procedure, if there is one, and if there is none of such a procedure, try to stimulate the courts to organize such a procedure, because I think
Ashley, could you explain what that is?
That is a possibility for the courts to invite scientists or organizations like UNHCR to bring forward their standpoints. And I think it's really enriching also for the courts to have such a procedure. And we know it, of course, at the European Court of Justice. So, but national courts can do such a thing as well, and also district courts. The other thing is to stimulate lawyers to start strategic procedures, because then you can bring a lot of asylum seekers together and press on a certain subject, and it will be taken more serious by the courts as well. And I think the just doing research at courts also may lead to very good contacts. At least I have really good experiences with that. That's what I wanted to say about that.
Thank you, Ashley. I know you have to leave, but thanks so much for your contribution to the conference, both the keynote and also...
I can say another 10 minutes. Thank you, Nick.
Great, great. Okay, now we're going to go on to John Campbell.
Yes, thank you. And Ashley, my experience in the UK is much less positive than yours in terms of access to judges. Tony may have had a different experience, but the judiciary has been relatively closed to me as an academic, even in terms of trying to initiate a prior contact, even just for general discussions. So what I will do instead is focus on a different question, and that is about the issue about north-south conversations, which I think are very critical, but also you might want to say west-west conversations across the Atlantic as well. There are many of us who are involved in research projects and many of us who are not in large projects, but who could make ourselves available as some kind of a discussant or part of a network that might be useful to other academics to be able to discuss their work, talk about their methods, etc. Right? Just as a kind of a background, I was when I had my research grant some years ago, I had the benefit of having 5 individuals on an advisory council, lawyers and NGOs who I managed to talk to each stage of the research over a 2-year period. And it provided me with excellent advice about who to approach, what to say, what kind of interviews I should be using, what kind of data I should be looking for. And I see no reason why, at least informally, we couldn't provide that to other projects who don't have the resources to create their own boards or advisors. So I, for one, would make myself available for that kind of North-South or West-West cooperation. Thank you.
Thank you very much, John. And now to Helena.
I think I'd like to focus a little bit on about what we can do to improve asylum hearings, really leading on from the sort of comments I was making earlier, because I think there are, it's a difficult world. It's going to be difficult to persuade the governments that this should be a priority. But I think even so, I think there are things that we should be organising around and focusing around. I mean, none of these problems, there are no easy solutions to this. And I think one of the difficult questions is around whether you want specialist judges or generalist judges. I mean, specialist judges can get dangerous and becoming case hardened and rather sort of cynical. On the other hand, generalist judges may not be so well trained, may not be so well may not understand the nuances of the law so much. I think certainly judicial training is really important, and I think this is beyond just around the law or the usual judicial methods. I think there has to be some kind of, and I think in the UK there has been some improvement in this, certainly in judicial studies, around sort of judges understanding themselves, the process of what judging involves, and getting some insight into how their own prejudices and biases may affect the way they perceive respondents. And I think sort of a more critical a more self-critical approach would be helpful in that. I was, quite interested to hear what Fabrice was saying yesterday about overt bias, not just covert bias. I think the question of resources and treating this asylum cases as important and making them as important as other cases. There tends to be perhaps quite a low prestige that attaches to becoming an asylum judge or an immigration judge in many jurisdictions. Again, Fabrice mentioned yesterday that immigration cases are awarded half the time in court that other administrative cases get in terms of the time allowed for a hearing and the number of cases they have to get through, which seem to me both a very literal kind of message about the value and importance of these claims, but also a kind of wider metaphor for the way that, for the lack of priority given to individuals. I think that the imbalances of power that are in the asylum, that are represented in the asylum process, need to be brought out more. I think that it is really important that judges enable, particularly with the difficulty of the legal representation, enable the voices of asylum seekers and prospective asylum seekers to be heard, and have a sufficiently critical view of the original decision-making process. I mean, I think the fact that, for example, in the UK, that decisions are made by Home Office officials who are subject to a very political agenda really raises questions about their independence, and the tribunal is an opportunity to rectify that. I would also be looking at modifications to the adversarial system. I'm not sure that moving entirely away from adversarial systems is the way to go, but I think there's certainly things that can be done around case management, case preparation, the role of the judge in ensuring as much equality of arms as possible. So I think there's lots of work that we could do around that would, in terms of improving the system. And just to say, my final point that I would like to say is just about the interdisciplinarity, that is so important in the research agenda and so important in bringing these points home, that the insights that I've learned from listening to people like Joe talking about the ethnography of courtrooms and the sort of whole experience of being in court from all these different perspectives is absolutely critical to understanding how you can make an asylum hearing effective. So I think, the call for continued interdisciplinary research across a very, very wide range of disciplines is still there.
Oh, that's fantastic. Thank you, Helena. Just to draw your attention, panelists, Yukari Ando has put a question in the chat which relates to her country, Japan. So do take a look at that. You may want to respond to that as well. I'll read it out in case, Tobias, you do. For all the panelists in your country, how the decision makers could have access to country of origin information. In my country, Japan, only one country of origin information specialist exists at the Immigration Bureau. Seems working, and also language barriers. Do you think that we are able to establish a world platform of country of origin information database? A bit short notice for you, Tobias, but perhaps the others could pick up on that as well. Over to you, Tobias.
Thank you. Country of origin information is really not my specialty, but I do think there is existing collaboration between the producers of knowledge and also those that use it. There are networks, so the question is, can you expand on these networks? And obviously with all of these things, the question is transparency. So who actually has access to the information, who actually has access to how it's used. So I think it's a really, really important question in kind of strengthening access to it and visibility of it. I want to maybe raise 2 points. One, the question of impact, and another the question of north-south comparisons, and that I'll try to keep it short. One, my experience with impact is that the key point, and I think you, Nick, and colleagues have done exemplary well in that, is kind of know your audience and find a way to find a language and communicate with them nicely. I'm talking about the PLP research paper that you published in December of last year, which is kind of suggesting ways to improve access to justice on first-tier tribunal levels. And I think the way you, and I'm just going to use it as an example because I think that's something that I found useful as well, is be specific to the situation that and be mindful of how it can be improved. I think what's interesting about your research paper, and I think that is a very, very fruitful approach, is that you acknowledge the difficult position that the people who make decisions are in, that you acknowledge that it's a difficult kind of bureaucratic procedure, and yet say and challenge quite hard that there are situations to improve on. So I think that kind of finding your audience and finding ways to communicate with the audience on different levels is I think extremely important, and that kind of goes back to the question of what dimensions of research into RST are we doing. The second thing is about the north-south comparisons, and I do think that we can learn a lot, and it's not just a question of can the South learn from the global North, but it's also the other way around. And I think for those of us who do qualitative research or do ethnographic research, we will know that a lot of the theory that we use, a lot of the approaches that we use come from studies of the global South, and I think there's a huge amount to be learned, particularly in migration research, in asylum research, also in that area. I've personally tried to get north-south comparisons on the ground as comparative projects, but I found it difficult, and maybe it would be interesting to hear from others, to get funders interested in, and also get reviewers interested in that perspective. The perspective often seems to be that if you do comparisons, you have to do like comparisons, so you have to kind of compare within Western Europe or within OECD countries, and kind of going beyond that seems to be kind of a problem of research imagination, maybe also. So I would say that's probably one of the key things that we all have to work on, and I like John's suggestion that we kind of also act more as advisors of each other and support each other, with particularly those of us who already have experience with comparative projects. Thank you.
Fantastic. Thank you, Tobias. Again, really interesting points. And we're now going to go to Cristiano. Can you hear us, Cristiano?
About the key themes they're most striking. I mean, of course, there were several very timely topics. One was for sure the fact about the gender identity and the sexual orientation in the refugee status determination. That I'm always referring to the reality here in South Africa, but extensively on the entire continent. That it's something that it really needs to be taken into consideration. Because as you probably know, there are several countries that they, some informally, but some other even formally criminalize, for instance, LGBT communities. And they criminalize, of course, homosexuality even with possible detention. If not even worse in several cases. Homosexual, they are often persecuted. And this topic needs to be linked with the COI, with the country of origin information, because not by, I don't know if it's done in bad faith or if it's done because there is no real knowledge of certain reality, but it's not unusual that several African countries return homosexual to their own country where there are forms of persecution. So it's always it's something that we really need to investigate on, because
we'll just give it a few seconds. I'm sure Cristiano will be back again. We've lost you for the moment, Cristiano.
I can see you.
Yeah, we're back again. You're back. Okay,
sorry. Yes. No, I will just. I'm sorry for the connection. No, I was just saying that you heard the part where I was linking the sexual orientation with the country of origin information, because it's not unusual, unfortunately, that homosexual or people belonging to LGBT communities, they are returned from one African country, they return back to their own country where there are in place forms of persecution. So it's still not clear if several refoulements or several rejection of claims are put in place because there is an ignorance of the host country in knowing the reality of the country of origin, or if it's rather decision that can be, sometimes they can be political, for example. So it's, also, unfortunately, also this, the COI, sometimes they are used in a very instrumental way here on the continent. And it's something that, of course, should be reviewed in some way. I mean, government should get more information, they should get more detailed information, but on the same time, they should also keep transparency and say, for example, in the case of LGBT communities, okay, we are returning this person because we are 100% sure that there won't be persecution. That it's very difficult, to do when you know that you read news every day on that given country where homosexuals are beaten or are even burned sometimes. So that is the relation, between the vulnerability, also about the children, for instance, and so children, women, because there are traditions like the genital mutilation in Africa that are still quite spread, by which women they ask for asylum elsewhere. There are practices that they need to be to be more investigate on, and government should be more aware of the actual danger that these vulnerable people run once that they are handed over the authority of the country of origin. It's really something that should really, I mean, if you want, we go back to the fact that authorities in many African countries, but not only in Africa, they don't show a lot of sensitiveness towards several situations, in fact. Yes.
Thank you, Cristiano.
You're welcome.
And Rebecca.
So I'll speak to a conference theme that jumped out at me, and that was just the rich empirical evidence that we've seen over the past few days of the ways in which this politics of rejection of the concept of asylum has not just been limited to the bordering practices that I think we do hear about in the media, when the public is paying more attention now to boat turnarounds, drownings, border deaths, children in cages is a big talking point here in the United States. Those types of anti-asylum seeker practices are getting some more attention, but what's become really clear in the past couple of days here is the ways in which the politics of exclusion are not limited to bordering practices. They're actually deeply influencing and infiltrating RSD regimes. And so I think that the political backlash to the notion, the very concept of asylum being something that is legally available to people who need it, is bleeding in. And I heard evidence of legislation being introduced in lots of different countries and taking many different forms, but in all cases being designed to really clamp down on availability for people to availability of asylum as a status, and making it much more difficult to gain access to that status. And so the other thing, I guess to put a slightly hopeful spin on it, that I learned from the presentation, some of the presentations in this conference, is that there's also been an uptick in backlash to those efforts by states. And I think that's to move to the next question about the role that researchers can play. I think researchers can play a really critical role here in using empirical work to inform and ground the politics of backlash to exclusionary politics. And I just want to give a shout out to Austin and the track project at Syracuse, because I think that it stands out in the United States as one of the really best examples of this, using data to inform the conversations about what specifically is being done to make our asylum system in the United States more unjust. And I think that kind of big data project is essential, and it's our role as people who understand what's going on to insert ourselves into these conversations and help explain, right? It's not just happening at the border. The border is functioning interiorly and bureaucratically, and helping to, bring to the extent, that we have deep knowledge of these systems, helping to bring that information to the public and explain the injustice of those government actions. So then I'll just, I guess, move on to another one of the questions, which was about networks. I really absolutely support John's important point about global networks. I think that governments and states are already very networked. They're sharing what they call best practices all the time, right? But they're actually worst practices usually, in my opinion. And so there needs to be a countervailing effort to actually talk about what are best practices and to share those as well, and for us to learn from each other across many different continents. I think one of the most disappointing things about our field as it stands now, and I'm very guilty of this, so I'm pointing the finger right at myself, is that we have overstudied liberal democracies, and we have understudied the countries in the world that actually host the vast majority of asylum seekers and are doing the vast majority of this work. We need to know a lot more about it. And I think to Tobias's earlier point about how one person doesn't have to do all of that, right? I don't need to go become an expert in RSD in Latin America. I can partner with someone in Latin America who's already very knowledgeable about their own countries, and build networks in that way, using common concepts to help us study every corner of the world without actually having one person go there. I think there's some hopeful signs in that direction. I'm really thrilled to be on the advisory board of what's called the RefMig project, which many of you may be familiar with. That's run by Catherine Costello, which is doing some really, really exciting work looking at RSD practices in the global South. And so I think there's another World Universities Network project going on looking at RSD practices that use alternative refugee definitions in the global South. So there's some interesting networks that are being built, and just more and more and more of that is what I'd really like to see in the future.
Oh, that's really great. Thank you, Rebecca. And if you could maybe tap into the chat, the networks that you mentioned, that would be really helpful. Anthony.
Yes, thanks. And thanks to Yukari Ando for raising the issue of COI, because that's what I was going to be talking about anyway. But before I do that, just a brief comment on John. John mentioned access to judges in the UK, and he's quite right. It's become much more difficult. I was lucky in being virtually the first person to do ethnographic research in the asylum courts, and I got fantastic access. I have lunch with the judges every day. Now you can still speak to judges, but they're not supposed to speak to you because they've not been given permission to speak to you. So you can't actually quote their names. So it's anonymous information that you get from judges now. It's certainly become more restrictive. But turning to COI, this was the theme that struck me the most, no doubt, partly because for the last 25 years, I've been providing it as a country expert from long before it was even called COI, which I think goes back to about 2005. It wasn't even a thing when I began providing it. I had the good fortune to chair the panel on COI yesterday, which was extremely enjoyable and for me, very provocative. And just to make one or two points that arose in that in my own mind. Famke Vogelaar made a very key distinction between the quality assessment of COI and the evidentiary assessment of it. There's been a lot of work on the quality assessment. The International Association of Refugee Law Judges, for example, and the European Court has adopted their standards for assessing COI. Now that's still important, and Stephanie Huber's paper was very revealing in the analysis of how the US State Department reports on human rights changed under the Trump regime, so that by and large, references to domestic violence and problems faced by women disappeared from those reports. And that raises the question, or raises the issue, that the apparent absence of COI can be just as telling as the existence of COI. What conclusions do we draw from the fact that a report makes no mention of domestic violence, for example? And the other point that Famke made, the lack of studies of evidentiary assessment, was partly addressed by the other paper in the panel by Laura and Valentine, which began to look at the ways in which German judges use COI, apparently, I mean, this is one hypothesis anyway, in ways that bolster conclusions that they might well have reached anyway. So the COI is used to justify a position that's been reached on other grounds. But that raises the general point for me that we know very little actually about how judges reach decisions. How do judges weigh up the country of origin evidence and the other evidence that comes before them? And how do they arrive at a decision on that basis? And I've interviewed several judges on this question, and with the best will in the world, judges are trying to be helpful, but they can't actually verbalize the process whereby this occurs. It's an ineffable process. And I suspect it's always going to remain that way. And that raises a real problem, because we have this black box here at the very heart of the process, which even the people acting within that black box can't explain and justify, even when they're trying to, and even when it obviously troubles them. Because some judges are troubled by this, others are not. Others seem to regard the entire process as completely unproblematic. But there's a whole set of issues here which may never actually be resolvable, but which are vitally important in terms of how the decision-making process actually works.
Thank you, Tony. Really important, interesting points again. I'm going to move on to Austin now.
Yeah, so this is a really rich discussion, and I just want to focus in on two things, and just to be brief. My past research is really focused on immigration enforcement, policing, racialized policing practices, the immigration courts, and all that. But I've come across two things recently that I think that I just want to share with this group, because I think it's more valuable actually in the context than some of that work. One is in the past year, I have been working a lot more with my universities, with Syracuse University's media team, to do a considerable amount of direct press outreach and media outreach. That's been really successful. This is not it's not a specialty of mine necessarily in the past, but I've learned a lot about it, and I'm actually working on a book right now with with the media director for Syracuse on connecting academic work to the media news cycle, specifically around the topic of immigration and how we can use data, qualitative and quantitative, to shape the national and international conversation around immigration, and especially asylum. So that's been really interesting. And I would love to talk more with folks. I'm starting to have some more conversations with other academics too, about how we can do this in different places. Because I've seen some real changes in terms of the tone and substance of some of the stories when I've worked with reporters, including reporters on the right, that I would not have been comfortable a year ago even answering an email for. So it's interesting to see, to navigate that space. It's been sort of new and sort of very interesting. So I think there's an opportunity for us to think strategically about how we connect some of this work to discourse outside of academic work. So I'll just put that out there. And the second one, just to address the question that was mentioned in the chat about, how do we get information from governments using Freedom of Information Act Freedom of Information kinds of laws, and the question was specifically about you would be very useful, but given that these people have control over what information to reveal, how do we resolve that? And there's obviously a lot to say about how to use freedom of information kinds of laws and requests and so forth. And that's sort of a specialty of TRAC, because that's how we get our data. So obviously much more to say, but maybe I'll just make this point. And I say this as someone who has been in sort of the legal geography world for many years now. I would just say it's very interesting how skittish we are, even as critical legal studies people, to engage the legal system and to litigate. And we litigate at TRAC to get this. I mean, there would not be data on immigration judges if we hadn't successfully litigated, because it's not as if the government's denying requests for information. That's not the end of the day. I mean, we're talking about asylum seekers appealing, but we have to appeal. If we want to get government information, we need to also think about what are the resources and the capacities and the connections that we can make with other people in this space to make more of that information available. And that's also a strategic ethnographic, research by doing kind of thing that can get information and make it available. So I put that out there just to say there might be some opportunities for us to think more about critical practice and critical praxis in this space, and not just as we would encourage asylum seekers, perhaps, and refugees not to give up just because they get an initial no. We need to not just give up because we get an initial no in terms of government transparency, and think about what kind of options might be available to us. If TRAC hadn't, if the Research Institute where I now work, if it had not litigated before I got here to get information on the immigration courts and asylum decisions made by immigration judges in the United States, there would be no insight whatsoever on immigration judge outcomes and asylum outcomes. So, I mean, that's possible now, but it's only possible because of intentional strategic work in the past. So thanks.
Thank you, Austin. Really important points there. Thank you. And you're my fellow geographer on the screen as well, which is great. Okay, so now we're going to move to Livia.
Okay, so this has been extremely interesting, and there are so many points that I would like to emphasize and share that you already have said. But maybe then I should take the opportunity to say something that no one else has said. And that's about the question how you would recommend the asylum appeal, that asylum appeal change in the future. And I just want to maybe start saying that I'm glad that so many picked up on this idea about comparison and having a more holistic perspective. But one other way besides doing that with different countries, that's what we kind of imagine first always, right? Is what I have found very productive is to compare cases within, in my case, Swedish administrative system, how citizens are treated compared to asylum applicants. I mean, for me, that's like the core normative point for me to see the differences. And if you look in the social legal literature, we also know that citizens are not always treated very good by courts, right? So we know poor people, we know immigrants without being asylum applicants, and we know people with disabilities, for example. So that's a comparative point that I want to raise as well, and that I have found very productive to study, for example, compulsory care cases of psychiatric care with asylum. And there you can find a lot of different injustices and problems that is not, and it kind of broadens the picture, right, about what is the problems particular for non-citizens and what is the problem in a broader sense in the legal sphere. But back to the point, what I want to see, the recommendation. So I think this is really difficult, and you could say so many small details of, where you want to kind of make changes. But for me, I think that the core problem is that the burden of proof lies with the applicants. And as long as it does that, I think that we will remain seeing large problems in this procedures. Because as long as the weakest party, without even the linguistic or the language capability of making themselves heard in the courts, will be the one with the burden of proof, many of these problems will remain. So that's just from where I'm coming. I think as long as we can't change that, we will still remain with the problems we have today. Yeah, I can stop there, but that's what I wanted to end by saying.
Great, thank you very much. So that brings us to the end of our list of speakers, in which case it remains for me to thank you very sincerely for what I think has been an absolutely fascinating discussion. I have taken probably about 6 pages of notes during this panel, so it's been absolutely fantastic. I really thank you very much for your time, and hopefully we can continue the conversations.